Why is it important for an applicant to be able to amend a patent application during examination?
Ivan, thank you for giving me the floor. Let me take the first thing I want to say. Thank you for getting me on the floor, for allowing me to speak together with Monique and Ankush. Thank you also to Patricia for organizing this all. You touched a very crucial point from the European point of view, because from my experience, everybody who came into contact with the EPO notices that it's probably the strictest, I will use this superlative, the strictest office in the world concerning undue amendments. And it's very, very important that you stay within the framework allowed by the articles, rules, and the guidelines and the ruling of the court, and to avoid that you spend or your client spends a lot of money for a patent, and then at the end of the day he loses or she loses it. I would like to share my screen. We tried it up front, it worked. Let's try it again. And I will go to the presentation and go on full screen. Let's see if it works. I hope you can see it. The most important article which we have in the EPC is the article 123.
Alex, sorry, but we have again the two screens, have the bigger one and the smaller. Perhaps it's better to go back to the other presentation form, because then we have a larger image. Yeah, I think we can work with that.
Okay. Then you probably see the slide I'm talking about in the middle, and on the left-hand side, you still see very small slides, which I'm going to speak about later. Is this correct?
Yes.
I'll try to make it as big as possible for you. Like this. Well, this article 123 EPC is the most important one, and I will take a few minutes or a bit of time to explain. Well, the first part of this article, and that's important to know, is it rules that you have at least one opportunity to amend the application from your own volition. That means whenever you have used this opportunity, it's up to the EPO to decide if they allow another opportunity. Normally, from the past, I would say they allow it. But just keep it in mind that there may be a point in time that they don't allow it any longer. In the usual processes, after the second office action, they will send a summons for oral proceedings, and then you could discuss it orally with the full team of patent examiners. That means 3 examiners. The second and probably most important part of this article rules that the European patent application or European patent may not be amended in such a way that it contains subject matter which extends beyond the content of the application as filed. We later will come to the reason why, but just in short words, that's the gold standard which we refer to here. Namely, we give at the end of the day the client or the applicant a monopoly for something which we in Europe understand is not a very good thing. So we try to avoid monopolies on the one hand side. On the other hand, we allow a patent, which is a monopoly, but then only for such subject matter which is novel and involves an inventive step, and therefore brings the technique up front. So everybody can benefit of it. That's a grounded idea of patents as such, and that's so that every third party can prepare him or herself. We have this second part of Article 123 to forestall that something will be patented which has not been disclosed originally. And the third part of this article is also an important one, especially if you think later of opposition proceedings, namely that a European patent as such may not be amended in such a way as to extend the protection it confers. So we have in Germany and Europe, we have a decision after we have granted the patent. We have to be careful that if we do amendments, we do not extend the protection. So first in the application process, we shall not amend in such a way that we extend to something which has not been originally disclosed. And later on, we also have to be careful that we, even if it's disclosed, do not extend the protection. When we talk about those three items of Article 123, then we have to use the eyes of a skilled person, because the Great Board of the EPO ruled about 20 years ago that we have to look with a skilled person eyes on it to judge if the subject matter of the claim can, and that's important now, directly and unambiguously be derived using the skilled person's general common knowledge. So if you read a few of those rulings, even the recent ones, you will probably always find a referral to this skilled person, and then it's directly, and that it has to be directly and unambiguously derivable. So whenever you do some amendments, that's what you have to keep in mind. So when you think about what is directly and unambiguously derivable, for sure, what is literal disclosed, for example, in the claims or in the description, all that we call explicit disclosure. You may also refer to implicit disclosure, for example, if you can clearly and unambiguously see it with a technical eye in the figures, the drawings. No problem should be at that. But be aware that it's directly and unambiguously disclosed. This will probably be discussed. The EPO, when they were set up, 70s, 80s, they came up with some guidelines, and it's always helpful to refer to those guidelines to get some feeling how they live this Article 123 and this decision of the Great Board of Appeal. So that's why I have enclosed this link. A few rules also have to be kept in mind. I have listed them, and this already brings me to two most important topics going along with it. First of all, if you have the feeling you have an explicit disclosure for your amendment, that's good, but you should take care that it's not an intermediate generalization, because that's what you normally tend to do. You have a disclosure of something, and then you would at least broaden it a little bit. And the question is, what can you do to broaden it? And the answer is not much. You should avoid to do this, and even be careful that you use it in the context as it is disclosed. So if you have some singular disclosure for something, then you should take care that the feature is not related or inextricably linked to any other features, because if this applies, you will have to also include it in the claim. And the overall disclosure justifies the generalization in isolation of the feature only in seldom examples. So that's what you have to keep in mind. And I already said that the EPO, at least to my opinion, is the strictest office worldwide. This strictness even shows itself when you would like to delete features, like you had feature A, B, C, D, and now you want to delete feature D and include feature E instead. Then you probably will have to do the so-called essentiality test and find out and show that the replaced or removed feature was not explained as essential, and that it is not indispensable for the function, and needs no modification from any other features involved. If you cannot show those three points, that's why it's also called 3-point test, then you will probably not be allowed to do so, as it is contrary to Article 123. So this probably will see a little bit weird to you, because the applicant, of course, is allowed to make amendments which he thinks or deems necessary, but with this framework, they show until which border you may amend your claim set. So I hope this already answers what are the rules. And Ivan, do you want more?
Alex, yeah, I would like to ask you for a clarification. If you can go back one slide, I see that there is a difference in the flexibility of amending claims when we are talking about a pending application.
Yes.
When you have a granted patent.
Yes.
So I'm not sure if it's clear that the second slide you're talking about a pending application or a granted patent. Because this is one point which is very important for us in Brazil. I think it's the same in India with respect to being able to not only I see here item 3, the European patent. This is a granted patent may not be amended in such a way as to extend the protection it confers. This is the whole issue about broadening the scope of pending claims. I understand that if the patent is already granted is one situation, if it's still pending is another. So the restrictions you commented on the third slide, are they related to a pending application or to a granted patent?
Well, from the logical standpoint, first of all, Article 123 concerns amendments whenever they are done. And then, for example, if you have a look at the first and the second paragraph, they both concern applications and patents, both. So only the third one concerns the patent. So whenever you are talking about amendments, you will have to fulfill Article 123, paragraph 1 and 2. So that's applicable in the application stage and in the patent stage. So the G decision is applicable in the application stage and in the patent stage. Same also for the intermediate generalization and for the essentiality test. That applies always. On top of it, you have 123 paragraph 3. This concerns only patents. So this then comes on top.
What is the usual advice related to the submission of amendments to the claims during examination?
I will try to be brief. As I said, this amendments topic is very important. Even if the EPO allows in the examination stage amendments, and later on in the opposition stage find that it's not okay, you will probably use the whole patent. So it is important to be careful. There are so many questions, and we are well prepared to help your clients along with individual advice. But let me just share the screen again, because we were discussing also the timeline quite a bit, and this timeline as well has a few restrictions which you have to keep in mind. One of the restrictions is that you are supposed to wait until you receive your European search report, because only then you will be allowed to amend description and claims as well as drawings. You have a good shot to do amendments, even at the early stage when you enter the European proceedings, due to Rule 70 and Rule 161. As I said before, later on, it's only with the consent of the examining division. So wait until you receive it. Be careful that you get all subject matter searched, because later on you will not be able to refer to it unless it has been searched. So if you get a unity objection and are allowed to pay additional fees for the unsearched subject matter, you should think about paying it to get it searched and then refer to it. You, as usual, will probably have to think about the examiner's reasoning and decide which way to go. You will always have to be careful to fulfill the gold standard and the therewith tied intermediate generalization and the essentiality test. So at the end of the day, it will always be important to stay along the framework given by the
whether there is any difference about the kind of changes you can do to your claims if you decide to divide the patent application instead of trying to amend existing claims.
Whatever reasons, the decision was not appealed. So that's the current standing as it stands.
Okay, thank you. Alex?
Yeah, I did like Monique's slide, because I just screenshotted it and tried quickly to show where the difference concerning, well, in comparison Brazil and Europe would be. And I just tried a quick sketch, and well, the first important step in time or time is the ESR. Then afterwards, obviously, more is allowed in the EPO that in Brazil and even in India, if I got it right. But then later, if we have the grant, it gets more difficult, as we have this Article 123, brackets open 3, brackets close, or third paragraph comes on top. But actually, as long as we keep the gold standard in mind, we can amend quite a bit, even new claim categories, even broadening the scope of protection if you are in the examination phase. Afterwards, no longer. But there are obviously some possibilities which you have. So that's what I took on from my side. And one message very important for me is be careful. If you make amendments, preferably go for explicit disclosure. Be care of the context, and always have in mind that at a later possible opposition proceeding, the patent in full is endangered if you do something undue concerning amendments.
Okay, thank you. Just one question, Alex. You mentioned that the applicant should be careful not to introduce claims for matter which was not searched. Is that right? Would a divisional at this point a solution? If you
Yes.
have, of course, if it is in the initial disclosure.
Yes. We were discussing, Ivan, quite a bit this unity problem, and one of these results of the unity problem which we have in Europe is that they are not going to search for inventions not belonging to the one invention. So then you can pay them for doing the search, and you are free to move the invention from the one to the other in the parent case. But if the client is not willing to pay at that stage, because, for example, the second invention is not important, he later can, of course, file a divisional and get it searched again. Yes, you can do so.